They say it's tough at the top, but if we're honest, it's a whole lot tougher for barristers at the bottom. Nerves, inexperience, sometimes even shoddy performance can mar any fledgling career. So I thought it would be useful to hear about the mistakes and the regrets of established barristers so that you, as the next generation, can avoid some of their errors. I'm Barrister Daniel Barnett, I'm an employment practitioner at Outer Temple Chambers, and I'm presenter of the Legal Hour on LBC Radio, and I'd like you to join me for a helpful expose of what barristers wish they'd done differently during their pupillage.
I wish that I had made greater efforts to internally network during pupillage and to get to know more senior members of chambers.
I was probably too shy about going out and offering to do things and making sure that people understood, what I was about and why I ought to be taken on so that they could then support me in my tenancy application.
I think as barristers, we're so focused on making sure that we are doing a great job in our own cases and to an extent getting to know solicitors that we forget to realise that it's really important to get to know the other members of your chambers so that you may be brought into other cases, so that you may talk to them about issues that are of interest to you or them, and generally to feel part of cohesive chambers.
I think the main lesson I learned in pupillage is that you really, in that period, have to give it your absolute all. It has to be the only focus in your life, and that isn't necessarily going to be much fun for your social life or your home life, but just for that period of time, hopefully 12 months, maybe 18 months, it's really got to be the absolute number one focus.
If I had my time again, I think what I'd do is concentrate in the second six on impressing barristers in chambers rather than trying to do my own advocacy. Doing your own advocacy is all well and good, but that doesn't actually get you marks when it comes to the assessment at the end of the year.
I think the one thing I would do differently is to probably stay local to where I grew up rather than moving to London. I think there's a lot to be said for finding your feet in a local area where you know the language, you know the roads. So when you're doing a road traffic accident, you may have driven down the road in question. When you're doing a criminal case, you may have drunk in that pub. There's a lot to be said for local knowledge to find your feet at the bar in the first place.
I would certainly do more pro bono work, not because of my involvement in FRU, although there's a plug there. It opens doors. One of my loyal solicitors who began instructing me off the back of a bit of pro bono work that I did for her in my first six. It secondly impresses your clerks, who will then be able to tout your acquired experience to their loyal solicitors, or indeed soon to be loyal solicitors. And finally, it makes second six, your practicing 6 months of pupillage, feel less like jumping in at the deep end.
I think the one thing I would do is to note down word for word what certain people have said when they're, for example, introducing a case or introducing a particular piece of evidence, sort of copying the phrases people use or turns of phrases, and then reproducing them when you're doing it yourself. It would have been incredibly useful rather than fumbling over my own form of words. So I wish I'd have noted down what other people had said so I could just use it myself.
I wish that I'd been quicker to ask for help when I was obviously out of my depth. No one expects you to know it all, and nearly everyone that you ask will be pleased to help you.
I think learning how to cross-examine is really hard, a long process, and it needs practice, it needs plenty of practice. I wish that I had the opportunity to prepare cross-examination in lots of cases before I actually had to do it myself and then watch somebody more experienced doing it.
Personally, I was a bit arrogant as a pupil and I would have kept my head down a little bit more.
I wish I'd gone to court more. There's a temptation to think that pupillage is just a long and stressful test of your own ability, and don't get me wrong, it is very much that. But it's also a unique opportunity to see advocates in action and discuss cases with them. The more you can do that with different barristers in different type of cases, the better for your practice in the long term.
I did a case which was my first big case in the High Court, where we were resisting an application for summary judgment in front of a High Court judge. I won this application and I was chuffed. And I came out into the Strand still wearing my wig and gown and bands and all the rest of it, because I was really not sort of focusing on what on earth I was wearing. And someone pointed out to me that I was in breach of the ethical code of the bar because I was advertising by prancing up and down the Strand in my wig and gown. So I had to take off my fancy dress and realise my mistake.
One of the things I wish I had done differently during pupillage is not go to the pub and have at least 2 pints with my pupil supervisor every day. I won't name him, he's now a High Court judge.
The one thing I wish I'd done differently on pupillage is not wear a bow tie on my first day. I know. The less said about that, frankly, the better.
The less said about what? Casper, I promise your secret's safe with me and with all my YouTube followers. Now, if you enjoyed this video, you could become one of those followers by subscribing to this channel. And you might also want to take a look at the 3 other videos I made in this series: top tips for getting a pupillage, top tips for pupillage interviews, and barristers' pet hates when reading pupillage applications. I'm Daniel Barnett. Thank you to everyone who has contributed to this series, and thank you to you for watching. Goodbye.